course of time, our law experiences changes alongside our society. The rapid development in the economic, social, cultural, scientific, and technological aspects factors greatly in the changes of law. Issues in regards to private international law can arise from determining the jurisdictional authority of the court, the laws that are applied, foreign legal decisions, and which national law applies to regulate a legal relationship, which relates to the availability of more than one applicable national legal system. The form of each legal act is assessed according to the state legislation and the place where the act was carried out. The aforementioned regulation is considered to be inadequate, seeing as it is a colonial legacy and because it still uses a statutory theory-style approach from the 16th to 17th century, emphasizing on the area of validity. Changing the rules of private international law can be done in the form of implementing and modifying the principles and rules of private international law into legislation. Another alternative is to build a complete private international codification or partial codification based on the urgency and expediency. This article will discuss the implementation of international civil law in various countries, specifically in Indonesia, Singapore, Malaysia, Thailand, and Brunei Darussalam, along with the cases that's been dealt with.
Malaysia prevent international law. Like the PPT content, Malaysia prevent international law generated from English common law, but there are traditional prevent international law situations where there is a conflict between two systems of municipal territorial, either statute or case law. This includes not only conflict between, say, the municipal system of Malaysia, but also conflict between the law of the federal state within the federation. For example, concern is a possible ground of divorce in Sarawak, though in no other part of the federation. These conflicts are inevitable in the federal system, and the rules of prevent international law provide possible solutions. Similar case to the content in the PPT, the opposite situation. A Chinese who has contracted valid polygamous marriage in Malaysia and who gained a domicile of choice in Singapore may enter into a strait, giving rise to a similar conflict. In this situation, prevent international law is limited use since it provides no criteria for resolving this conflict. This quite frankly is a choice based on convenience, though there is some case for its justification on the ground of public policy and natural justice.
Firstly, the issue which needs to be apprehended by the local court when faced with a cross-border or transborder dispute is whether the local court can assume jurisdiction over a person who is not a resident in a country. Can the local court understand the case under the law on its own state? The basic concept of jurisdiction is that the court will apply their own domestic law to determine whether it possesses the necessary jurisdiction to try a case. Section 22 of the Court Director Act 1964 provided as follows. Subject to the limitation contained in Article 128 of the Constitution, every High Court shall have jurisdiction to try civil proceedings where A. The cause of action arose, B. The defendant or one of the several defendants resides or has his place of business, C. The fact on which the proceedings are based exists or alleged to have occurred within the local jurisdiction to the court. As an example, we will bring up the dispute about Yi Cheng-ming versus Teo Astin. The background of this case is as follows. The defendant had in 1999 made a stay application in a Malaysian court to stay the proceeding in favor of Singapore, which was rejected. During the application in 1999, the salient issue in this case was whether a sum of money the exchange between the plaintiff and the defendant was a loan or a gift. However, after the application for a stay of proceeding was rejected, the plaintiff applied for leave to re-amend the writ of summons and statement of claim. The new claim then included the original sum of money contested and the declaration that one of the defendants was holding a certain property on a resulting or a constructive trust for the plaintiff. The property was situated in Singapore. Taking these matters into consideration, it was held that Singapore was indeed the better forum. The decision was based primarily on the fact that when it comes to the matter of land, it is really the legislature that governs. Seeing as how Singapore is the legislature, it would be improper for a Malaysian court to make decisions that will ultimately affect land in Singapore.
Like rules of private international law in other countries, Thai Conflict of Laws, BE 2481, 1939, recognized the principle of party autonomy clearly embodied in Article 13, Paragraph 1. It stipulates that the question as to what law is applicable in regard to the essential elements or effect of a contract is determined by the intention of the parties thereof. The Thai Conflict of Laws acknowledged both express and inferred choice of law. It should be added that the process of ascertaining inferred choice of law is very difficult, requiring a judge to carefully consider. In addition to interest statement or legal term contained in agreement, another relevant circumstance is an arbitration clause, the language, the standard form of the contract, the habitual residence of the parties, and so forth. If a judge does not scrupulously scrutinize another party's circumstance, the outcome of the decision might be deemed to be unfair, illogical, or even absurd. A careful analysis of a judgment is very helpful. Since Thai Conflict of Law adopt the doctrine of party autonomy in Section 13, which means it differs slightly with another jurisdiction in the world. The main difference focuses on if the parties fail to make any choice of applicable law in their contract, and the court could not determine the intention of applicable substantial law of the contract either. Can we reach the conclusion of the substantial law of bashing of the application of Section 13? The answer to this question might be no. If the contracting parties failed to make any choice of substantial law in their contract and the court failed to ascertain the intention of them pursuant to Section 13 of the Act. The approach of lex partiae, the law of the country where the parties have the same nationality, and the lex loci contractus, the law of the country where the contract is concluded if the parties have different nationalities, will be used to determine the applicable of the contract at the first. If the contract is concluded between parties at a distance and the place where the notice of acceptance reaches of the offer cannot be ascertained, the law of the place where the contract is performed shall govern the contract.
Section 13, paragraph 1 makes it clear that in case where such intention, expressed or implied, cannot be ascertained, if the parties have the same nationality, the law applicable is the law of common nationality of the parties. If they are not of the same nationality, the law of the place where the contract is made shall govern. In other words, under this paragraph, the process of determination of applicable law under Thai legislations could be a three-steps analysis. First of all, the court will seek for the intention of the parties in context of the contract or by considering some relating elements if the choice is not expressly made. If this attempt fails, under the circumstance that the parties share some nationality, the substantial law of the country where the parties have the same nationality, the substantial law of the country where the parties have the same nationality will be applied to the contract. Otherwise, the substantial law of the place where the contract was concluded will be applied to govern the contract. Section 13, paragraph 2 further make it clear that if the contract is made between persons at a distance, the place where the contract was concluded is deemed to the place where the notice of acceptance reaches the offerer, and if this place can be ascertained, the law of the place where the contract is to be performed shall be the governing law. Such article needs to be analyzed and examined carefully. Case example. In BE 2525, the Thai Labour Court and the Thai Supreme Court had an opportunity to employ the Act on Conflict of Laws BE 2481. The case concerned inferred choice of law. In such a case, the contracting parties have the same nationality, in this case American. The contract was concluded in Singapore and was infringed in Thailand. Then the plaintiffs sued the defendant before the Thai Labour Courts, claiming compensation for breach of contract. The Thai ruled that in the absence of an express choice of law, the contract was made Singapore. Therefore, the court went on to arrive at the conclusion that the implied choice can be deducted from the place where the contract was made. Hence, the applicable law was the Singaporean law convened as lex loci contractus. The Thai Supreme Court reviewed this case and decided that no circumstances indicated both the expressed and implied choice of law. So, the law applicable was, according to Article 13, paragraph 1, the law common to the parties when they are of the same nationality. The governing law was thus the American law. However, in this case, the litigant failed to prove the content of the American law. Thereby, the Thai court refused to apply such law to the case in question. Instead, the court applied the Thai law to this case on the grounds that the parties failed to prove the foreign law before the court.
Some remark on the resorting to Thai private international law by the Thai Supreme Court should be mentioned. First, and perhaps most significant of all, the Thai Labour Court confused the inferred choice of law with lex loci contractus, which function as a connecting factor separate from the inferred choice of law. Regarding the scope of chosen law, according to Article 13, the party autonomy is only applied to two problems, that is, the condition and effect of contract. With respect to the problem of limitation of choosing foreign law, this issue, like other questions, has never been seriously discussed in academic circle. In addition, a Thai court has never ruled on this issue in dealing with the problem of the imitation of freedom in choosing law according to Thai conflict of law. The present author thinks that the chosen law should be connected with the juristic relation of the contract in one way or another. The reason support to our opinion is that Thai judges usually tend to employ Thai law, the civil and commercial code, rather than foreign law. Thus, from actual practical reason, we be able to prove and use foreign law conveniently. Thai private international law should not allow the contracting party to choose and pick any system of law on earth as a governing law. Rather, the chosen law should be closely linked with same as the contract, that is lex loci contractus, lex loci solutionis, or the parties, that is lex domicile and lex patriae.